All right, government students. So we need to talk about the Supreme Court for two reasons, right? The first reason being the Supreme Court is generally the one branch of government that doesn't get a whole lot of press. I mean, it's not that exciting in the way that like the president, mouths off or tweets something and then it becomes a scandal. The Supreme Court usually stays pretty low key, but the decisions that they make have generational impact, right? Because if they make decisions about the law and the way the law is supposed to be interpreted, it could last for a lifetime, right? And so it's really important to know them for that reason. And two, the Constitution is actually a little bit vague about the Supreme Court. So it's important for us to understand what's going on with it so that we elect officials that will do the kind of work that we need them to do when they're vetting these people and nominating them, okay? So let's talk about the Supreme Court. So currently there are 9 Supreme Court justices, right? The Constitution isn't particularly clear about how many justices there need to be. There have been different iterations of the court where they've had sometimes fewer and sometimes more, but we've settled on 9. And there's probably a pretty good reason for it, because the way that the court works is once they hear a case, right, all of the justices make a determination, right? And so if you had an even number of people on the Supreme Court, you could end up in deadlocks where there's no decision. When a no decision does happen, it goes down to whatever the lower court, the last court before it got to the Supreme Court says. But that could be kind of confusing, right? Because there's lots of lower courts. So one state Supreme Court could say one thing and another state Supreme Court could say another, and it would kind of leave the law a little vague. So we have 9 because having an odd number allows for it to be a clear majority-minority kind of setup. Now here's the deal, right? Since the Supreme Court was really kind of put into place back in 1790, there have been over 100 justices, right? And the thing with the justices in the Supreme Court is the Constitution isn't really 100% clear on how long their term serves. It says that as long as they're in good behavior, they get to stay in the Supreme Court, which means the only way they could get kicked out is if they get impeached, right? If they get kicked out for doing something grossly incompetent or illegal themselves, right? So essentially, justices serve for life. The average is 16 years, but some justices serve for way longer. We're going to get into that, especially some of the ones that are on the court right now. Now, the way that it works, we already covered it, is the president chooses who they want to be in the Supreme Court when a vacancy opens up. Now, here's the deal. If a president wanted to elect, say my dog, right? Could they do that? No, because my dog is not a human. Could they nominate anyone else? Yeah, because the Constitution isn't really clear on that, right? So the president chooses, and then it's up to the Senate to make a call on it. Now, when they're selected by the president, nominees for the Supreme Court have to fill out like these super complicated questionnaires, and then they go up in front of the Senate Judiciary Committee. And that's like just a small group of senators that hear things about like laws, right? And then who gets to be on the courts, right? They investigate them, they interview them, and then they make a recommendation for the whole Senate. The whole Senate, all 100 senators vote on them. It only requires at the moment a single majority, so they only need 51 votes to confirm a senator, right? If there's a tie 50-50, then the vice president gets to step in and make the deciding vote, okay? So in theory, right, even though these are apolitical people, they are not part of the Republican or Democratic Party in the way that we would vote for them, like the representatives we talked about in the first 5 weeks, but they're still nominated by Republican or Democratic presidents, right? And so of the 9 justices, currently 5 of them have been nominated by Republican presidents, and 4 of them have been nominated by Democratic presidents. And I'm going to try to go in chronological order unless I screw up, which is entirely possible, and then I might need some assistance from the government wizard. Okay, so first on our list is this guy Clarence Thomas. Now, Clarence Thomas was nominated all the way back in 1991 by George H.W. Bush, Pappy Bush, right? Now, his nomination was actually kind of rocky. He was credibly accused by staffer Anita Hill of sexual harassment in the office. There's like a whole docudrama that you should totally check out about that situation. But when you think about it, he's been there for almost 30 years, man. Like, that's a huge impact, right? For most of my life, he's been in a position to make decisions about whether or not laws are interpreted in a particular way, right? Okay, now we're going to go over to 1993 when we have Bill Clinton nominating Ruth Bader Ginsburg. Ruth Bader Ginsburg is like a super feminist icon and has fought her entire life to make sure that women are treated equally and are represented in like the legal system, right? Okay, then we're going to go 1994. You have Stephen Breyer, who was also nominated by Bill Clinton. Okay, jump ahead in 2005. You have Chief Justice John Roberts, who was nominated by George W. Bush, baby Bush. And the Chief Justice is responsible for kind of presiding over the court. It's kind of like a fancy title, right, for him, okay? And then after Roberts, you have in 2006, Samuel Alito, who was also nominated by Bush, right? Then we jump ahead all the way to 2009, when we have Sonia Sotomayor, the first Latina, the first Latino, person who is nominated by Obama, right? 2010, you have Elena Kagan, right? And this is where we get a little bit of a hiccup, okay? So in 2016, it was Barack Obama's last year in office, and Antonin Scalia, one of the justices who was nominated by a conservative, died, right? Ended, right? And so he nominated one more person, right? And he nominated this guy, Merrick Garland. Now, Obama was very keenly aware that if he nominated someone who was super liberal, super on the left, that the Republicans in Congress would fight back. So he chose someone who was pretty much in the center. Merrick Garland, aside from having a really cool name that sounds like it should be a spice on a spice rack, was well respected throughout the entire legal community, right? Because he had been a prosecutor and he oversaw the domestic prosecution of terrorists on our soil, right? The Oklahoma City bombing was his case to prosecute, right? And so he was widely respected as being like a straight shooter. But the Republicans in Congress, led by Mitch McConnell, who were in charge of the Senate at the time, refused to even hear his vote. That's only happened 4 other times in our entire history where they just refuse to we're not even going to vote on the dude. We don't want to. We're going to leave it up to the electorate. We're going to let the people elect a new president, and the new president is going to nominate them. That's going to be a way of giving to the people. And who did we elect after Barack Obama? It's cool. I'll give you a minute. Yes, if you said a lumpy sack of potatoes with a bad hair job, you win. Yes, and so there was no nomination for almost a year until that guy got into office, right? So this is where we come up with our last 2 justices, right? So in 2016, Trump nominated Neil Gorsuch, right? Neil Gorsuch is a strong, super by the book conservative, right? And then you have the last Supreme Court justice that was nominated, and his name is Brett Kavanaugh, and he sure makes me proud to be a Brett. He's famous for saying this.
You're saying there's never been a case where you drank so much that you didn't remember what happened the night before, or part of what happened?
You're asking about, blackout. I don't know. Have you?
Could you answer the question, Judge? That's not happened. Is that your answer?
Yeah, and I'm curious if you have.
I have no drinking problem, Judge.
Yeah, nor do I.
Okay, thank you.
Yeah, that's Supreme Court Justice. Right there. That's what you want. He was also credibly accused of sexually assaulting someone when he was a teenager. And that was a huge deal a few years ago during his nomination process, okay? So, really quick, now that we've kind of gone over who's on the court, I just want to kind of touch on 2 things really quickly. First is, it matters who we elect as president and who we elect in the Senate, right? Because who we elect as president decides whether or not we're getting conservative judges or liberal judges, okay? So, I just want to now kick it over to the technical side, because I want you to understand, how do cases even get to the Supreme Court? So watch this video from Vox, and then there's an assignment that I want you to kind of answer down below, okay? Good luck.
TV shows made it seem really easy to appeal to the Supreme Court, like when this lady wanted to fight her speeding ticket.
I am going to win this case. If not here, I'll appeal to a higher court. If necessary, I'll take it to the Supreme Court.
Or on Gilligan's Island, when Thurston Howell is locked in a bamboo jail and he says,
I'll take it to Supreme Court.
but even though they make it sound like a right, nobody is entitled to an appearance at the Supreme Court. That's entirely at the discretion of the justices. And they choose very carefully. Only a small number of cases get to the Supreme Court, and it's getting smaller. Roughly 8,000 cases are submitted each year, but only 80 cases are accepted. That's a 1% acceptance rate. And to get to that 1%, most cases start at the bottom. The federal court system consists of 3 layers, and the lowest is the district level. If you lose in a district court, you can appeal to the circuit level. Most of the United States is divided into 11 circuits, but there's a 12th for DC and a federal circuit that mostly hears patent and military cases. Above the circuit level is the Supreme Court, the highest court in the land, as long as you don't count the basketball court that's above the Supreme Court. And to get to the Supreme Court, nearly all cases require submitting something called a petition for a writ of certiorari.
The writ of certiorari, which is shortened usually to writ of cert.
A petition for the writ of cert is a written request asking the Supreme Court to hear a case, instead of asking the court to resolve the facts of a case, which are nearly always settled in lower courts. The reasons for granting the petition concern important questions about federal law.
The overarching goal of the court is to make sure that federal law is the same across the country. And so by federal law, I mean the U.S. Constitution and laws passed by Congress.
Professor Green clerked for Justice John Paul Stevens, where he became very familiar with cert petitions. That's because the clerks review cert petitions for their justices, who then choose to grant a petition if it passes the rule of 4, meaning that 4 justices want to hear the case. When the court does not grant cert, it does not imply a decision.
It doesn't mean that it agrees with the lower court. It doesn't mean that the individual justices agree with the lower court decision. It just means that the court has decided that this particular case is not a case where the court is going to choose to set law for the whole country.
If cert is granted, a case probably falls into one of 3 categories describing most Supreme Court cases. The first is a case of national importance, such as when the court decided Bush v. Gore in order to help determine who had won the 2000 presidential election.
Drawing on very rarely used legal powers, the Supreme Court has, for the first time in American history, decided to step into a legal dispute in the midst of a presidential election.
A second type of case is when a lower court issues a ruling that invalidates federal law. An example is Gonzalez v. Raich, in which Angel Raich, a California woman, challenged federal drug laws after agents destroyed marijuana plants she had been consuming for medical use. On her appeal in the Ninth Circuit, judges ruled in favor of Raich, deciding that she was compliant with the state law authorizing her use of medical pot. But that ruling conflicted with federal law prohibiting marijuana use.
So when the Ninth Circuit said it doesn't apply, that means if you're a medical marijuana user in California, then you can use it without fear of federal prosecution. But if you are a medical marijuana user in Florida or in New York, then it's still banned under federal law.
By ruling on the case, justices were able to establish the authority of federal law prohibiting the use of medical marijuana.
In the Raich case, the Supreme Court overruled the Ninth Circuit and said that the federal drug laws can apply to local marijuana use, which means that someone like Angel Raich can still be prosecuted under federal law, even though she can't be prosecuted under state law.
Third, the court accepts cases in order to resolve a split decision in the lower courts. This happened in the case Obergefell v. Hodges, where a Sixth Circuit ruling that banned same-sex marriage conflicted with rulings in other circuits that had upheld the right to same-sex marriage.
The Obergefell was someone living in Ohio who wanted to marry his same-sex partner and was not permitted to do so under Ohio law. It made its way to the Sixth Circuit. The Sixth Circuit said you have no right to be married because you're a same-sex couple. And that created a split, a division of authority between the Sixth Circuit, which governs Ohio, and a number of other circuit courts. And so once that happened, it was fairly clear to, I think, most legal observers that the Supreme Court was likely to hear the case because it meant that the federal law, the federal constitution in this case, applied differently in Ohio than it would in Pennsylvania, for example.
By ruling in favor of Obergefell, the court resolved a circuit split and made same-sex marriage a right nationwide. But these 3 categories are just a framework for understanding why the court might select a case. They are not rules. Ultimately, which cases get to the court depends on the decisions of individuals, the sitting justices of the U.S. Supreme Court.